Another topic of confusion that I have with a lot of clients that come in to see me, and it's a really understandable one, is what is the difference between a will and a living will? They actually are not similar whatsoever, and I really have no explanation as to why they chose these particular kind of confusing terms to indicate these two very different estate planning documents. But I'll explain the difference for you. A will is going to determine who gets what out of your estate. It's going to control the distribution of your assets when you go through the probate process after someone has passed away. It's going to say who gets what, as well as, a number of other things that it may include, such as who your executor is going to be, and if you have minor children, who the guardians could be. And there's other things that we can put in there. A living will operates while you're alive. A living will is an expression of your wishes for your end-of-life care. It is only going to be considered if you're in a terminal condition or permanently unconscious state. Your doctor and another doctor that's examined you have to agree to a reasonable degree of medical certainty that you are in one of those two states. If you are, a living will says not to use any procedures to prolong your life artificially, to basically just give you comfort care and let you die naturally. There's an optional provision within a living will, and this is the provision that a lot of people think about, and understand that it is always optional for you. So if you are in a permanently unconscious state, meaning a vegetative coma with no higher brain function, meaning you cannot suffer, you cannot feel pain, you cannot feel the lack of food and water, if you're in that circumstance, and your doctor and another doctor, of course, that's examined, you have to agree that you're in that permanently unconscious state, meaning that vegetative coma. Do you want food and water stopped? This is not a decision that you want to leave to your loved ones because it is a burden to them. Okay, so let's say you're a parent and you are in a permanently unconscious state. Your child, if you don't do a living will, your child is going to have to figure out whether you would want them to basically pull the plug or not. No child wants to go through that determination for their parent. Instead, if you have the gift of a living will, all they have to do is honor your wishes as expressed in that living will. They will not have that burden, that lifetime burden on their shoulders of, I made the decision to pull the plug. No, all they have to do is say, I want to honor mom's wishes. She put it right here in a living will, so I don't have to make this decision. And so that's what's so important about a living will and doing one. As you can see, totally different than a will. They are not the same document whatsoever. You want to have both. You want to say, these are my wishes for my end-of-life care, and here's who I want to get my stuff. Hi, this is Laura. If you like the video that you just watched, please feel free to subscribe or just hit the like button. You can also go to my website, which is lbesq.com. So that's LB as in Laura Blumensteel, ESQ as in I am a lawyer. You can go there and you'll see a lot of blog posts, and I try to have a lot of educational material up on my website. I update it regularly. So if you want to go over and get more information on any of the things that I've been talking about today, please feel free to check it out at lbesq.com. Thanks so much.